Wednesday, April 29th. Okay. So though I'm going to tell you that there will probably be a brief, something very brief. I don't. My life is being very weird here. Something very brief for Friday, but it will probably supplement what we're doing, what the new edition is for today. So we're continuing on this theme of address to trial procedures and due process, procedural due process of the 14th, how the procedural due process, 4th, 5th, 6th, 8th, to a lesser extent, applies to the states. There was a series of Supreme Court decisions made in the 1960s, and that's what A25 has to do with. Okay. So first, though, before I get into it, let me back up into the arrested trial procedures pair deck. I backed up for a day, so it's not due till tomorrow. If you're while you're watching this Wednesday, so that's due till Thursday now. Again, please answer all the questions. Some people in the world, especially in the world, we're struggling with that, or we'll dive into it and then questions. So there's a pair deck. You've seen the pair decks before. This is where I generally go through all the arrested trial procedures. Then I'm going to explain practice the Supreme Court. So where do all these procedures that we just take for granted, from being read Miranda rights, right to remain silent, right to have an attorney, all of these come from the Bill of Rights, but they didn't apply to the states until the 1960s. And there was a series of Supreme Court cases, starting with Matt versus Ohio, which I talk about in the pair deck pretty extensively. The lady who successfully fought to the Supreme Court, saying that her right to privacy, to her right to had been, not right to privacy, but her right against illegal seizure had been violated, and the exclusionary rule comes into play, that because they didn't have a search warrant to go through her home, and they find these pornographic scene materials, and they try to prosecute her for it, and she says that you can't do that because you did not have a search warrant. So they agreed, because she didn't have a proper search warrant. They didn't have a proper search warrant, that that her evidence had to be excluded. It's known as the exclusionary rule. Gideon is the classic case of an indigent defendant, someone who cannot afford an attorney, petitioning the Florida Supreme Court, for an attorney. At the time, June 1961, he was accused of the crime of breaking into this pool room, petty theft, smashing up several items, and stealing money. He's an older gentleman, and some witnesses claimed to have seen him. It was kind of a frame up, and they really didn't have any other evidence there. And for this petty larceny, he couldn't afford a lawyer. He defends himself because the state of Florida will not provide him a lawyer, saying they only provide lawyers in capital cases. Okay, so therefore, he appeals. He files. It's an amazing situation, and we go into it more in law too. The actual full details of the case. We don't have time in this short outline to go through it, but he files a petition from jail. Petition for certiorari in his own hand, which is very rare. The Supreme Court takes it a pauperous, because he can't afford to have an attorney, and they grant this petition for certiorari. Again, four justices agree to hear the case, and they say, "Yep, all felony cases must have, and actually any arrest you have the right to an attorney. If you can't afford one will be provided for you." There's a whole set of structure within the court system, public defenders, court appointed attorneys that work in the court system now as a result of this case. Miranda and Escobedo are related to each other. Escobedo is the defendant. Danny Escobedo said he wanted an attorney, and he was denied one during interrogation, and he made incriminating statements, and because he didn't have an attorney present, in the situation, and the conviction was overturned because he wasn't providing an attorney. The Fifth and Sixth Amendment rights to not having to be incriminated against yourself Fifth and sixth, the right to an attorney, are kind of very intertwined because sometimes you don't know that you're incriminating against yourself if you don't have an attorney present. Because an attorney understands the law and whether you're going to incriminate against yourself much better. So that's what happened with Danny Escobedo. He answers questions in interrogation that end up, he wasn't aware that he was incriminating himself to a certain extent, and a lawyer would have helped him. Miranda, 2 years later, is the idea that he didn't ask for an attorney, but he was also not English speaking, and he signed a confession stating his guilt, but he never was informed of his constitutional rights to remain silent or the right to legal counsel. He needed to understand those, and he petitioned all the way to the Supreme Court. And Miranda decision is handed down that state that not only do you have the right to advocate for yourself, but you have the right to know that you have the right to know that you can don't have to incriminate against yourself. Fifth Amendment and Sixth Amendment, you have the right to an attorney. I call them the big four cases. The big four. This is like the bedrock. So there's some readings here. The readings are for Miranda, Gideon, and Mapp, and then there's a Prezi for for Escobedo. And go through the Prezi, and then there is a pretty extensive, and there won't be anything much more formal on Friday, to a practice test. You can take this as many times as you need, using the readings, using the Prezi, using class knowledge, using the arrested trial Parrott Act might help you as well to answer these particular questions. Mostly the readings in the Parrott Act will help you. You'll get feedback, and it'll tell you which ones you got wrong. You can answer this as many times as you want to get the grade that you want on it. Okay, probably end up being a half a point for them, half a point to maybe 25 for completion of it. But you can answer it as many times as you want to get the grade that you want. Okay, on it to answer. But you're only going to get when you get the feedback, you're only going to get the questions. You're not going to get the answer. You're only going to get the questions that you got wrong, and some of them are fill in the blank. They're closely based in the reading and the Prezi, in terms of that. And then the Parrott Act explained, the law enforcement video discussion. Some of you still need to look at the law enforcement video discussion. It looks like haven't done that yet. Looking at 6 of these, I went through them all. I've graded them all that I had. The law enforcement presentation that's overdue. Some of you still need to look at those and do that. Quite a few of you. And then the Edpuzzle, cybercrime that I've explained numerous times, the importance of reporting cybercrimes as we and what they are, and how businesses are dealing with them through the eyes of one business consultant. So again, that's a little bit behind. We've already moved into now the last phases of our Unit 2 here, the arrested trial procedures, the procedural due process relating to the 14th Amendment. 14th Amendment applies procedural and substantive, but for our purposes, procedural due process. Those arrested trial procedures that are in the Bill of Rights, 4 through 8, to the states. Those series of Supreme Court decisions in the 1960s that you're going to go through, the big four, near and dear to my heart, is what you're going to look at. And then online grading and learning surveys, please take those if you have not done so. And we will talk to you on Friday.